How can I get full custody of my child? Hi, I'm Bill Farias, founder of Farias Family Law. We had an individual a couple of years ago contact us in a panic. He has a little girl. At the time, she was 8, and she was staying primarily with the mother. And our client was seeing his little girl a couple of times a week. The problem was that the living environment with the mother was deteriorating. So the little girl was not being properly cared for. She was missing school. When she went to school, she was dirty, sleepy. The mother, unfortunately, had been abusing substances. Her housing was unstable. And so this guy was in a panic, and he contacted us, and we got him on the right track, and he eventually got custody of his daughter. So how do you get full custody of a child? The court looks at a number of factors in determining a custody arrangement that's appropriate. The overarching principle is best interest of the child. So that is the standard. The court looks at a number of factors to figure out what's in the best interest of the child. Some of those factors are: what has the parenting arrangement been? Which parent is the child more bonded to? Does either parent suffer from mental illness and or substance abuse? Is that being treated? What are the parties' work schedules? Do they have a history of abuse or neglect? And a number of other factors. So the court puts all of that together and tries to figure out the arrangement that is best for the child. As far as how to go about actually technically getting custody of the child, if the parties are not married, the mother has an advantage in the sense that the mother is presumed to have custody of the child. If if an unmarried father wants custody of a child, that father has to file a complaint for paternity or a complaint for custody support and parenting time, depending on whether he is on the birth certificate. So if he's not on the birth certificate, then he has to file a complaint for paternity. If he is on the birth certificate, it's a complaint for custody support and parenting time. If the parties are divorced or in the process of divorcing, then that has to be figured out through the divorce. So one issue that comes up often is that people will come to a private agreement. People are splitting up. They come to an agreement on how to break down the parenting time. And then a significant amount of time goes by and they want to change that. And the problem is that if you create a precedent, then the court will consider that precedent in deciding parenting time. So the way this commonly plays out is people are splitting up. A party will come to an agreement on some parenting time, not happy with it, but just wants to see the kids, and just lets that sit for a period of time. So let's just say it's a father and he's seeing his kids just once a week. If that goes on for a big stretch of time, it then becomes more difficult for the father to go into court to get a significant chunk of parenting time. So the bottom line is, do not come to an agreement on a parenting arrangement without first talking to a reliable divorce attorney and being fairly certain that that agreement is going to put you in a good position long term. So how do you get full custody? You have to file properly. The court tries to do what's in the best interest of the child, and you have to be careful about making agreements that are going to serve as a precedent and may end up hurting you later. So I would suggest talking to a reliable attorney first before nailing down those terms and going into a schedule. If you have any other questions about this, you can call us at 508-675-0464. You can email us at info@fariasfamilylaw.com. If you found this helpful, you can subscribe to our channel and share this with anyone you think might benefit from it. And you can find us on Facebook at Farias Family Law. Thank you. Have a good day.